Good afternoon, everyone. It's 1 o'clock, so we'll make a start. Welcome to our webinar on reorganising your workforce effectively. My name's Simon Lapthorne. I'm a partner in the team at Kylie Thompson Casely, and I'm joined today by my colleagues Laura Chapman and Scott Worthy. You'll see that Laura's actually coming up as Kylie Thompson. We're not literally, I'm not literally joined by Scott and Laura as we're observing appropriate social distancing, and Scott and Laura both on their laptops in their own offices. Some of you attended our webinar during the first lockdown in April when there were 2 million cases of COVID-19 globally. That figure's now increased to a staggering 25 million with nearly 850,000 deaths. And as you're aware, here in Auckland, we've just come out of level 3 lockdown, and across the globe, countries are trying to get to grips with the economic effects of lockdown. So as well as the obvious health consequences of the pandemic, one of the unfortunate effects has been the impact on businesses and on employment. Many companies have closed and others are being forced to reorganise. So in today's webinar, we're going to focus on a number of kind of key points, best practice steps in restructuring processes, how to navigate some common challenges involved in a restructure. We're also going to briefly look at the government wage subsidies and implications for restructuring, as well as the impact of COVID-19 on restructuring and workforce reorganisations. We'll look briefly at some alternatives to redundancy before finishing with a brief run through of some of the immigration implications that you may need to bear in mind when you're carrying out a restructure. There is an opportunity for you to send in questions using the chat function on the webinar, and we'll try and finish the kind of webinar around 10 minutes to 1 so that we can address some of those. But I'll now hand over to Laura, who I think is going to start off with best practice steps.
In fact, Scott will help us with some best practice steps in restructuring.
Oh, thank you, Laura. Seamless transition.
Yes, good afternoon, everyone out there. I hope you're all keeping well and are adjusting to this new environment. While we are in a new environment in terms of how we all deal with some quite difficult challenges and COVID-19's effect on society and workforces, we are still in a situation where the law, as it was before COVID, still applies to everyone. And so it's important to start when you're thinking about restructuring or redundancies with the basics. And if we move to the first slide, what are some of those basics? Well, the first is to have a rationale, or what the courts call a genuine reason for the restructure. Now, while COVID has had a big impact, it's not enough to just say, the impact of COVID has been devastating on the business, therefore we're going to shrink the workforce. What you need to do is set out in detail what the impact has been and what you're proposing to do about it. That will also probably involve you reflecting on how you think the business will go over the next few months. Because one of the things that employees might say is, well, just write it out. But I think one of the things an employer can say is, we've had significant reduction in demand, and we expect that to continue given all the evidence we have. So the rationale has to be carefully described and laid out, and with some supporting evidence for that. One of the things that you should be mindful of, though, is including financial information about the business, because if you include that as a justification for the restructure, employees may well want further information about the company's finances. Once you've set out that rationale and understand what you're proposing and proposed new structure, whether that's reorganising the business or simply shrinking the workforce or shrinking roles, then the next step is to think about good faith. And the statute has 2 key requirements, and I'm sure you're all familiar with them. The first is that you provide relevant information about the restructure. and that will generally be set out in a letter, or it may be set out in a PowerPoint, or it may be set out however you want, but relevant information that supports the rationale. And so that's why it's so key to define the rationale carefully and precisely, because once you've defined that, you provide the information that supports that rationale. And the second, of course, is to consult with employees before you make any decision about the outcome. It's important to know that, of course, in the consultation period, particularly at the moment, you may have to be extra flexible because people might be ill, people might not feel comfortable coming to a face-to-face meeting. So you can conduct the consultation process in good faith, via phone, via Skype, in person, in a combination of ways that make people feel comfortable. As we talk about that consultation process, it's important to understand that feedback from employees, there may be a range of feedback from employees, to anticipate that to some extent in the proposal, but also to listen carefully to that and then to respond in the outcome of the restructure. Those same rules still apply, and it's important to give employees a chance to give their feedback, whatever that may be. The final point there is selection, and we're seeing this become increasingly important because a lot of businesses are simply reducing the number of roles. So you have 5 sales consultants, but due to lack of demand, you only need 3. And you are selecting which 2 roles, which 2 incumbents should be dismissed for redundancy. So it's important that as part of the consultation process, number 1, the employees see the selection criteria and can comment on it before it is finalised. Now that criteria might be a mix of objective and subjective factors, or it might just be last on, first off. But whatever it is, employees get a chance to see it before it's set in stone and make some comments. The second issue that's coming up quite often is that once the selection criteria are applied and you identify the 2 employees who are lowest and you want to dismiss under the criteria, that should be given, that proposed outcome should be given to the employee so they can contest that. They may have a different view about their skills and experience, and they probably will, and they get a chance, should get a chance to let you know about that before you confirm the outcome and before you confirm that actually this particular employee is going to be dismissed. So if we go to the next slide, I alluded already to one of the common challenges, and that is we are seeing a number of grievances where the employee has done a great process up right until the end. So they've consulted, they've had a good rationale, the proposal makes perfect sense, and the employees have talked about selection criteria and given their feedback. But what they haven't been able to do is say, no, you've got the selection criteria application wrong. It shouldn't be me, and here's the reasons why. And it's at that part where employers need to give employees a chance to give that feedback before the decision, the final decision, is made. Again, this is consultation. You don't have to agree with the employee's feedback or perspective, but you do have to listen to it and take it into account. The other thing that employees can do at this point is be helpful. They can correct an error. Sometimes employees will see an issue in the selection criteria application that should be fixed. And if you fix it, it may make no difference. That person is still the person selected, but it allows you to have a smooth process and one which is fair to everyone, which is what an employer wants. The other thing that's important to remember in selection criteria is that, and the problem we've seen, is that where performance is being assessed, sometimes there are incomplete performance records. And so it's difficult to rely on past performance where the records are not quite as complete as you would like. Perhaps a performance meeting has been missed and not made up, and therefore employers should think about whether that's a good factor to be using in the selection criteria, and in fact the last performance meeting isn't able to be assessed or factored in. The second point there is timing. Because of disruption to the workforce, working from home, all these things, processes are taking longer, and that's okay. You've got to be flexible with that if you possibly can. And in particular, where there are selection criteria to be applied, it may be an extra couple of days to have that consultation meeting with the employees. But it's really important that that meeting take place, especially if you've run a really great process up until that point. Moving away slightly from the issue of redundancies, the other thing we've seen is employees commenting on the agreement process that was undertaken to change someone's job. So for instance, employers asked employees to take 80% of their salary, or they asked them to move to 4 days a week, or there might be any number of other changes, giving up a car park, for instance, or something like that, where the employee helps out the business by giving up some sort of entitlement or benefit or money. If that's what's occurring, then of course it's perfectly lawful and legal for someone to agree that. But in the process of agreeing with an employee, there are special good faith rules that should be followed. The first point is that the variation or the change should be presented to the employee in writing. The employee should then be told that they can get independent advice and given the chance to do so. It's also important that there be a genuine understanding and agreement by the employee of whatever they are signing. So the best practice advice is that if an employee is giving up something or surrendering a right, that in the end is not that great for them because they're losing some money or they're losing a car park, you should point that out. You should say, here's the written document, but what that means is you'll go to 4 days a week, we'll pay you 20% less salary, so that the employee fully understands the issue and can't say later, hang on a minute, I didn't understand that. You didn't explain that to me, and I got lost, and it was all very urgent and rushed, and in fact, you can't rely on that change. So that's really the last point about information, that the information provided should explain the variation or the change proposed, and it should, of course, be accurate so that the employee understands what he or she is getting into. So with that, I think I'll hand over to Laura.
Thank you. We thought taking a slightly different approach on this, one of the things that obviously applies in relation to a lot of people at the moment, or a lot of employers at the moment, is wage subsidies. There's still a few of these wage subsidies around and some level of support for businesses experiencing a downturn as a result of COVID-19. And they obviously have some implications for restructuring, in particular in relation to making redundancies. So just to give you a bit of a recap as to the subsidies that are currently in force. So of course you remember what we Aucklanders refer to as the first lockdown, given that we've now had a second here in Auckland. The first lockdown we had the general wage subsidy, which is a 12-week subsidy. And I'm sure everyone is relatively familiar with the terms of that subsidy. Following on from that, of course, there was the wage subsidy extension, and applications for those actually closed yesterday. And the period for application was from the 10th of June until yesterday, and the terms of the subsidy were relatively similar to the original wage subsidy, save that the key difference was that rather than a 30% drop in revenue, there needed to be a 40% drop in revenue over 30 continuous days out of the 40 days prior to the application for that wage subsidy extension. What we now have in place, and of course some employers are still continuing to receive the wage subsidy extension depending on their application date, but because of the resurgence of COVID, there's now a resurgence subsidy, and applications for that are open until 11:59 PM tomorrow night. Again, that is similar terms to the wage subsidy extension, and that again it has to be a 40% decrease in revenue because of COVID-19 for a 14-day period this time between 12th of August and the 10th of September. So it's still forward-looking to some extent in terms of when you might be experiencing that drop in revenue. And this time that is only a 2-week subsidy, whereas the extension was 8 weeks and the original was 12. The final one is a little bit more fiddly in terms of the qualification requirements, but is the leave support scheme. That was formerly the Essential Workers Leave Support Scheme, but it's now open to all employers. And that's available for employees who can't work because they have to or they're required to remain at home. It's not for everybody who is required to remain at home, and I'll talk about some of the exceptions there, but it is eligible where someone has tested positive for COVID and has to stay at home and until they're required to or allowed to come back to work after being tested negative and having no more symptoms. Or for people who have come into contact with someone who has tested positive and are required to stay at home for 14 days. So that being a difference. If you see at the moment, there's a lot of people obviously who have had to have a test for COVID-19 or feel that they need to have a test for COVID-19 because they might have been a casual contact around or in a place where someone who tested positive for COVID-19 has been. And they are required to stay at home until the test results are released, but they are not required for the whole 14-day period to stay at home, in which case they're not actually eligible for that leave support scheme. So you have to be required to stay at home for the 14-day isolation period. So effectively, that's people essentially who are close contacts of people who have tested positive for COVID-19. The next category are people who are at higher risk of contracting COVID, and the Ministry of Health guidelines have recommended that they stay at home. So this generally happens in levels or alert levels 3 and 4. At the moment, the guidance is not necessarily that people who are at higher risk stay at home while we're in level 2. So that won't generally apply at the moment. And again, if you have household members who are at higher risk and that household member or employee itself has been asked to stay at home, you can qualify for that leave scheme. And the people who are at higher risk, again, I think we're probably all very familiar with that by now, but it's people over 70, people with certain medical conditions and have compromised immunity, or another category that's perhaps more recent, but pregnant women in their 3rd trimester of their pregnancy. And again, it was a criteria under alert levels 3 and 4 that those people would stay at home, but not under alert level 2 at this stage. And now the difference between the 21st of August and now is if you applied for the leave support scheme before the 21st of August, you needed to show some sort of financial effects from COVID. So i.e. you had to show a 30% in actual predicted revenue decline. And now you do not in relation to the leave support scheme itself. Now, the key thing to note with those 3 schemes is you can only have one scheme in place in respect of each employee. So, of course, if you're receiving support under one scheme, you can't then apply for obviously a second scheme. Now, what restrictions do we have in relation to the wage subsidies? Well, the key restriction that we know about and have heard from before is that you are required to retain employees for whom you have made an application for a wage subsidy or a support scheme during the period of that subsidy. Now, again, that's not going to be as onerous as it was under the first scheme because it was a 12-week period. We then had an 8-week period and a 2-week period, so it's less onerous in terms of that now. Also, most employers are taking the view as well that during that subsidy period, you can carry out redundancy consultations and you can potentially even issue notice of redundancy as long as your redundancies don't take effect before the end of that wage subsidy period. The other thing that we are we're seeing and getting questions on in terms of the wage subsidy is what can we use the wage subsidy for? So again, if you have issued a notice of termination to an employee, you can't apply for, after issuing notice, you can't apply for the wage subsidy or any of the wage subsidy schemes while the employee is on their notice period. if you do issue notice after you have applied for the wage subsidy scheme, the wage subsidy can be used towards an employee's notice period payment. So again, it's still wages, so you can use that in respect of that payment. What you can't use the wage subsidy scheme for is any type of contractual severance or redundancy payment that's over and above that, that payment of notice. So you have to retain your employees, as we said. It can't be used for severance. But what else? What else can you do with the subsidy? And when do you have to pay it and not repay it? Well, obviously you have to repay the subsidy if you're no longer eligible for it. So if your revenue is not as affected as anticipated, and you've made your application on predicted revenue, then you may have a requirement to pay that back. But what about if individual employees leave? So there's different rules depending on why your employees leave. So for example, if an employee voluntarily resigns, you can use the remaining subsidy, so the subsidy doesn't have to be paid to that employee, to pay wages of other affected employees in those circumstances. Similarly, if an employee doesn't earn as much as the subsidy or the value of the subsidy itself, then you can use the surplus to again pay other affected employees wages. If you, for example, if you dismiss an employee for a reason other than redundancy, so if you have a gross misconduct situation or the performance situation, and in fact you still have a surplus of subsidy once they've been dismissed, then generally you should repay the remainder of that subsidy, and you have notification obligations to income and MSD in relation to the change of your workforce. And again, you have a notification obligation if your employees voluntarily resign. So what are the consequences if you breach it? Well, I've just been talking about the repayments to the government if you do happen to have a change in circumstances around your employees, and that is the main consequence. Is most of the time you will be required to repay that, and you should do that on a voluntary basis if you know that you're in that situation, and it's very clear that actually you're no longer eligible for a part of or a wage subsidy. Then there's repayment options to do that quite simply online, and you'll just need certain information to be able to do that. You may also, of course, have breached employment laws in the way that you've carried something out, but that is not related directly to your wage subsidy. It isn't a claim, simply by reason of the fact you may have breached a declaration. Isn't usually a claim the employee can make directly against you. They can, however, complain via a fairly easy complaints process online about that, and of course everyone who receives, or every employer that receives the wage subsidy is included in the list of employers that you can look up again quite easily online. And there have been, as we've seen in the media, kind of increase in those sorts of complaints about the way in which employers are using wage subsidies. And more extreme cases, or in some cases, you could be subject to a fraud investigation if you blatantly breach the rules and you haven't looked at voluntarily repaying or otherwise. Then there could be a fraud investigation. And again, employees in some of the websites have quite easy links to be able to make complaints if they think their employer has acted fraudulently in relation to that. So that gives you a bit of an insight on kind of what we're seeing, what the restrictions are, and what the wage subsidies look like at this point in time. And with that, I'm going to hand back to Scott to tell us a little bit about what we've seen in the authority around redundancies / wage subsidies / effects of the COVID outbreak. Scott, I think you're on mute still.
I reminded myself not to do that, but of course I have, like everyone has, I'm sure. As a result of these changes to the workforce we've been seeing, obviously there is going to be some litigation and some people challenging what employers have done. And probably you may well have read in the news about two particular authority decisions which have come out which affect the wage subsidy and, in essence, the payment of 80% of a person's normal wages. The first point to remember, though, that these are employment relations authority decisions, they're binding, but both of them have been appealed to the Employment Court. So the Employment Court will look at this all afresh and make its own decision about these issues. So watch the space, but it does give us an indication of how the authority is approaching these issues. And of course, if someone does bring a claim, the authority is the first port of call. So the first case involves a company called Gate Gourmet, and Gate Gourmet makes meals for planes. So they're to blame for all those terrible pasta bakes and terrible mashed potato. They're the people who do that. And obviously, as a result of the COVID travel restrictions, they have a lot less work than they used to in terms of producing meals. They have a workforce which is essentially paid the minimum wage to produce these meals. And this Gate Gourmet, and what happened in this Gate Gourmet case is that the company told employees that essentially we don't have a lot of work left. We have some work for some flights, but not a lot of work, and certainly not the work we had before. And so if you are not on the roster to come to work, don't come to work and stay home. They also said to deal with the situation, we're proposing essentially that you are paid 80% of your normal wages. We'll apply for the wage subsidy, and you can, if you want, use your annual leave to top up to 100% of your normal wages. They made this proposal to the union who represented these 5 employees who brought this case. And as far as we can tell from the authority decision, the union replied and said, yes, we agree to that, but subject to any legal requirements and subject to minimum statutory requirements. And that, in essence, has become what the case is about, because these employees were on the minimum wage, and an employer must pay employees the minimum wage for their work. And the employer's point of view is pretty simple. They say, well, the employees weren't at work. We didn't need them to do any work. They were at home. Because they were essential employees, they could have come to work, but we didn't need them. Some employees did come to work to do some jobs, but we didn't need you. We didn't roster you. And so therefore we didn't have to pay you the minimum wage. We didn't have to pay you anything, but we still paid you 80% of your normal wages and got the wage subsidy for you. And the employees said, well, hang on a minute, we were still employed. You could have made us come to work. What you paid me was wages. I got 80% of my wages. I want 100% of my wages because the Minimum Wage Act says you must do that. And the authority agreed with the employees and said essentially what was happening here was that people were still being paid wages. And this is a really important point, that the wage subsidy an employer gets from the government is to help that employer pay someone's wages. And in this case, they were still being paid wages, just 80%. And the authority said this is really simple. If you pay someone wages, it must be at the minimum wage rate, and you weren't doing that, so you have to pay them at the minimum wage. The authority member also said these employees could have come to work, and this is an important point. They were essential workers. They could have come to work. It's just that you, the company, told them not to come. And in that situation, they're entitled to be paid their wages, and that must be at the minimum wage. So that decision is being challenged, and the Employment Court will give its view. But I think it is important to note here that these were essential workers who could have come to work, but the employer said, look, I just don't have any work for them. And what the authority said was, well, in that situation, you can either pay them the minimum wage or you can make them redundant. That's your choice, but you have to pick one of those. The other case that the authority has dealt with, again, has been appealed, is the Dove Hospice case. Now, the immediate difference here is that despite being about a Dove Hospice, it wasn't, the case isn't about the hospice that Dove provides. It wasn't about caring for people who are terminally ill. Rather, this is a case about people who work in the charity shop. So it's a retail shop like any other. And during lockdown, of course, the level 4 lockdown, it was closed because the government said you must close retail businesses. And the government said people who work there must stay in their house and can't leave to go to work. In that situation, Dove Hospice said, you can't come to work, don't come. We'll apply for the wage subsidy for you, and we will pay you 80% of your wages. They didn't get the employees to agree to that, they just told them what would happen. Subsequently, later on, the employees were made redundant. But this case is just about whether Dove Hospice was allowed to pay them 80% of their wages for the period of the level 4 lockdown. And the authority said, no. The first point was that the employees hadn't agreed to this change. And that was the key point really for the authority. The authority said someone was entitled to wages. You can't change that employer unless they agree. You didn't ask them to agree, and they never agreed. The second argument, which was made, related to, well, hang on a minute, rather like the Gate Gourmet case, Dove said, well, we didn't have to pay them anything because our shop was closed. We couldn't open it. We had no work for them, but the employees couldn't come to work anyway. They couldn't leave their house to come to work. They had to stay at home. So we couldn't offer them work, but they couldn't perform any work. And so when both parties are stopped from doing the work wage bargain, in other words, you work and I'll pay you, the employer said, well, we don't have to pay them anything for that period of time. And the authority didn't accept that. The authority said these employees were ready and willing to work. Yes, they couldn't leave their house, but that wasn't their fault. And so the employer should have asked for a variation to their employment and to their wages for the period of the lockdown. It didn't do that, and so it is liable for the extra 20% that was not paid. Again, that one, as I said, has been challenged, so we'll see what happens. But the key difference there, the key difference between the two cases is that the Dove Hospice case occurred where the employees were not essential and so were locked down in their houses. And we'll have to see what the employment court says should happen when the employer cannot provide work because the government says so, and the employee can't come to work because the government says so, and it's illegal to do so. So those are the very tricky issues that the authority is confronting right now. And these are unprecedented issues. No one's had to decide these issues before. And so what outcome we'll get, we don't know. But we will certainly keep everyone updated on what happens with these very interesting cases. So I think Laura's going to take over from here.
I am. So just coming back to then what those cases have highlighted is some looking at alternative ways of working. So in these cases, of course, an employer has its right to make employees redundant, but what we are hoping, I think in most cases, is that there may be periods of time when people can't work, but we want people back at work and looking to pick up business again as soon as they are able to. So really it's considering to what extent do you even make redundancies, and to what extent can you apply alternative measures to reach the goals that you're looking for, whether that's business efficiencies, cost savings, or essentially just putting people on hold for a period of time. Some of you, I'm sure, would have attended the webinar that we did back in April that Simon's referred to, and we had a similar graphic in that, looking at what can we think about in terms of alternative measures in relation to employees that don't have the effect of actually terminating their employment. And I thought I'd just touch on some of the different options that we are seeing. Of course, as Scott's highlighted, you can agree to most things in relation to variations to contracts, as long as they're not cutting across minimum statutory rights. So again, minimum wage was an important one in one of the cases Scott's just been talking about. So that is something to think about. But generally, if you are reaching agreement with your employees, and genuine agreement, so you have given them information, there is a lot that's possible. So we're seeing a reasonable amount of reduced or amended hours, so looking at smaller or slightly smaller roles. We have seen a lot of wage and hiring freezes. They are coming up reasonably often, as you might expect. There are a lot of other cost-cutting measures, and one of the interesting ones that we're seeing that is different this time around to perhaps other recessions or other downturns in business is looking at actually releasing the capital that companies spend on commercial leases. And that is really a cost-cutting measure that some people or some employers have been looking at, but it's not quite as simple as it seems, and there's a lot of considerations that go into something like that, and I'll talk about that again in a minute. Another thing is looking at alternative incentives. So cash bonuses obviously have been affected quite significantly, particularly if they're pegged to a firm's EBITDA or their earnings, essentially, or revenue over a period of time. So if a cash bonus is not going to be worth anything, then are there other ways in which you can incentivize employees, and is that through share or phantom share schemes that are going to be set up in the future? And that's, I think, something that we will see a bit more of in future time. Reduced salaries, again, it's something that people are more willing to agree to in this kind of environment when they're looking at holding on to a job. And again, we're talking about a percentage decrease in salary, potentially even the same level of work, although that seems less popular than agreeing to reduced or amended hours. We've seen some kind of good news stories in relation to industries where they've been able to redeploy or effectively redeploy their workers into other industries. And as we've seen in the news, New Zealand was one of those employers that was able to reach agreement with other employers essentially to hire their staff for periods of time while they're effectively stood down from their current employment. So it was an interesting way in which to keep a hold of a workforce, or have a workforce that is has the skills, etc., that you need, that you're not paying, and you're not having the financial costs of having them on your books for that period of time, but they're nonetheless still there and available for when the economy hopefully, or the business hopefully, picks up in future. Other things, there has been some training and re-education, looking at using the resources that people have. So we're still seeing some of this. I think it generally hasn't been as innovative as it potentially could be in future. I'm sure we still will see changes. But generally, I think the things that we thought we were going to see are the things that we are generally seeing across the board. There's some things to think about when you're thinking about alternatives to redundancies, though, and we've touched on some of them already, particularly when Scott was talking about obviously looking at getting consent, giving proper information for consent, etc. And something I wanted to touch on was just looking at first, the employment laws haven't changed significantly in this respect as a result of the COVID-19 outbreak. So if you are looking to make material changes to terms and conditions, those will usually require consent of the employee. And again, and even if your contract, for example, says that you can make unilateral changes, etc., that won't give you carte blanche to just make changes to those employees' agreements. So it's important to remember that. Something else we're also seeing, though, that is just worth flagging is that material changes to an employee's position can also lead to a redundancy situation. So in some circumstances where an employer has been trying to reorganise its business for efficiency, what they've actually ended up doing is opening up a redundancy situation, and employees have actually put their hands up and said, well, actually, I think I am now redundant, and have taken redundancy in those circumstances when the employer was actually trying to avoid that in the first place. So there's two things. I guess the first is if you are reorganising your business in a way that you're actually changing positions as opposed to the situation where Scott was talking about earlier, that you're reducing a number of roles essentially, but retaining some of those roles and deciding on who should be given which role. You are actually changing the organisation to the extent you will have new roles available, and you're looking to redeploy somebody into that role. You do have to give some thought as to whether A, your contract talks about whether you have the ability to redeploy your staff into a suitable alternative role, and B, whether it actually is a suitable alternative role. And if a position's character, the kind of nature of the position has been altered to the extent that it ceases to exist in its current form, the courts will generally take a number of factors into consideration if they're deciding if there is actually a redundancy situation in those circumstances. So, for example, whether the pay and benefits are the same, whether the work's going to be provided at the same location, and coming back to what we were talking about before, it is possible in some circumstances that your employment agreements contemplate a physical workplace. So if you are deciding to no longer have commercial premises and ask your employees to work from home, one of the factors you need to think about is how material a change to terms and conditions that might be in respect of the workforce that you're talking about. So whether the positions have the same hours of work, and again, if you have significant changes to hours, so for example, if there's weekend work where there wasn't before, or there's a shift work that there wasn't necessarily the same sort of time frames before, there are questions as to, again, how material that is in relation to the employee's job and whether or not that results in a redundancy situation. Again, a difference in status might make material changes, and that might be because you've removed all or a large portion of direct reports from somebody, and or their reporting structure becomes different under a reorganised business. And again, if the role requires similar credentials and experience, so linked to a status, it might be that the role is actually a demotion overall, for example, at least in the eyes of an employee. So all of those things do really need to be taken into account. And then I've put at the end a kind of other considerations. It's a very typical lawyer point there, that there will always essentially be other considerations in relation to looking at reorganisations, and unfortunately they depend very largely on the fact scenarios that you're looking at in terms of your reorganisation. But for example, taking the working from home rather commercial premises example, not just how material a term of the contract is it to have a physical workplace, but also how does that affect the way in which the employee works. So is their reliance on technology going to be completely increased? Will they have to learn new skills to be able to do that? What are the effects on productivity for the business anyway, in terms of having employees in that environment and being isolated? And that's not necessarily one for consent, but it is something the business needs to think about in terms of its restructuring. There's obviously health and safety requirements as well around having an employee's workplace being their home, and to what extent can you accommodate those health and safety requirements, and also what do you need to be thinking about. So I guess none of us know specifically as yet what the long-term effects on mental health of employees being from home are, and are they likely to be significant, and does it depend on your employees. So there's a lot to be considered in relation to reorganising workforces, but that's not to say any of this is insurmountable. So we've seen a lot of employers quite successfully reorganise their workforce to try and retain a number of employees. And again, it comes down to whether or not they've got robust processes in place to be able to do that. So looking at that those steps that Scott talked about earlier in terms of good faith and consultation, and looking at getting that agreement and or consent by way of providing extra information to employees. So with that, I'm going to pass over to Simon to talk to us a little bit about what we're seeing on the immigration side of that as a result of the COVID-19 outbreak.
Thank you, Laura. To conclude the webinar, as Laura mentioned, I'm just going to briefly run through some of the immigration considerations that you need to bear in mind when you are carrying out a restructure. So it might be the case that within your organisation you've got large numbers of employees who are employed on employer-specific work visas, and those work visas generally are subject to certain conditions. So, for example, the visa may state that the visa holder can only work in a specific role or at a specific location. It may stipulate a minimum number of hours of work, or that the role is full-time. And in addition, it might provide that the employee must be paid a minimum level of remuneration. And again, as many of you will be aware, there are a number of employer-specific visas. The most common include essential skills work visas, talent accredited employer visas, and long-term skill shortage visas. And those last two, so the talent accredited visa and the long-term skill shortage visa, both provide a potential pathway to residence. Now, as both Laura and Scott have mentioned, if as part of a kind of workplace reorganisation you're considering varying terms and conditions, then as a general point of employment law, then you should consult with the employees and obtain their agreement. But when you're imposing a variation, it potentially has significant implications for those employees who are subject to a visa, because if they are no longer employed in accordance with the terms of the visa, so for example, if you reduce their wages or their hours of work, then both the employer and the employee could be found to be in breach of their immigration obligations. There's a further significant consideration from the individual's perspective in that they may also have applied for residence based on their current employment. So for example, if they've applied for a skilled migrant visa, they would be awarded points based on skilled employment. And if you vary their hours of work again, or their remuneration, or their responsibilities, then it can potentially jeopardise their residence application if they no longer meet requirements of the visa category under which they've applied for residence. So kind of best practice in order to comply with visa obligations is that if you are changing the conditions of an employee's visa, then the employee should apply to Immigration New Zealand immediately to vary their work conditions. Now, if an employee is made redundant and their employer-assisted work visa ends, then they're going to need to apply for a further visa in order to continue to reside in New Zealand lawfully, or alternatively, if their visa has already expired, then they may need to make an application under Section 61 of the Immigration Act for their visa application to be considered while they are currently in New Zealand unlawfully. Second point I want to kind of briefly touch on is selection criteria, to the extent that it impacts on kind of migrant workers. Scott's talked more broadly about the selection criteria from an employment perspective. But generally, in terms of redundancy selection processes, then you can't lawfully give preference to New Zealand citizens and or residents. And there's no obligation for you to do so. And if you do give preference to New Zealand citizens, you do run the risk of discrimination claims. And while visa status in itself is not a prohibited ground of discrimination, nationality and citizenship are. Generally, after a visa has been granted, an individual can work in New Zealand, as I mentioned earlier, provided that they meet the terms and conditions of the visa. And if you select individuals for redundancy on the basis of visa status, as I mentioned, they can argue that the selection is discriminatory on the grounds of citizenship. Finally, I just want to kind of provide you with a brief update in terms of visa processing times. So those of you who saw our webinar in April will know that we kind of provided an update back then as to the kind of processing times, which were pretty frightening. There hasn't been a significant change in that. One development that you should note is that in July, the government did announce a further automatic extension for employer-assisted work visas that expire between the 10th of July and the end of this year. And that extension is a period of 6 months from the date of expiry of those visas. So that includes individuals who had their visas extended under the epidemic notice, which again was issued, I think, back in April. So this will again include essential skills work visas and work to residence visas. The extensions only apply to employees or visa holders who actually currently reside in New Zealand. So it doesn't apply to offshore employees who are offshore. So again, in terms of best practice, if you have employees who are employed on this type of work visa, then they must apply for a new work visa to remain in New Zealand. So sorry, just to clarify, if you have employees in other types of work visas, such as partnership visas or post-study or working holiday visas that are set to expire, they will have to apply for an extension. And again, we would recommend that in terms of best practice that you ask your employees to provide you with copies of their visa extensions and that you keep a log of those on their personnel file or in a central database to ensure that you're not employing anyone unlawfully, so that you don't continue to employ somebody after their visa has expired. In terms of those processing times that I mentioned, the backlog from the last lockdown or the original lockdown means there is still a significant delay in processing times. And again, you should keep that in mind when you're monitoring visa expiries and when employees are considering submitting a new visa application. Priority is currently being given to essential workers and to temporary visa holders who are already in New Zealand. But Immigration New Zealand has also indicated that applicants should consider applying online rather than submitting a paper application. And that's because the paper applications will take longer to process and because INZ itself has reduced capacity. So it's got less staff working in its offices here and offshore. So I think that concludes our webinar. Just looking to see, Laura, perhaps you can kind of jump in as well. I don't think there are any questions yet. Sorry, have just got one's just popped up. So question is, I have an employee on a work visa who went overseas before the lockdown and remains offshore and cannot return due to the closed borders. If the visa expires while he's offshore, does he mean does that mean he will not get the automatic extension? I think that does mean that you won't get the automatic extension. I understand that it does only apply to employees who are in New Zealand at the time. And I mean, unfortunately, what we are saying is that lots of employers who have employees who were kind of offshore prior to the kind of border lockdown are experiencing significant difficulty in actually, or actually getting permission from Immigration New Zealand for them to be let into the country, and that includes, kind of CFOs, large clients of ours. Despite the fact you can argue, I think, that the role of CFO is an essential role. So there doesn't appear to be kind of consistent application of immigration policy, and unfortunately, there is actually no right of appeal against a decision to reject an application for a special exemption for somebody to be admitted. Any other questions? So again, got a further question.
Sorry, Simon. I think there's some questions via the chat function as well.
Yeah, sure. Well, I'll just, perhaps Laura, I've just got another immigration question that's come up, and then I'll hand over to you via the chat function. So next question is, to what extent do I, as a New Zealand entity fully owned and ruled by Australian head office, have to consult with my New Zealand staff if Australia decides that my customer service function should be outsourced to Australia to realise synergies? The decision has effectively been made. Do I still need to pretend it's a proposal only? Actually, it's not an immigration question, so perhaps I'll hand that one over to Scott.
Well, I mean, this is an issue that confronts New Zealand employers where the decision is made overseas, whether it be in Australia or Singapore or London. The reality is that to the extent that there is a New Zealand employing entity, so company New Zealand Limited, then yes, the obligation is to consult. It is to consult about the proposal, and certainly part of the task then is to put as best face you can on the instructions or decision that has been made overseas. If it is possible to go back to that decision maker and say, that's fine, I understand, but New Zealand law says we have to consult. So we understand it's your strong preference to do this, but we have to put this to employees first before we move on. And obviously there is a legal risk there that if employees find out about this or request further information, they will make a claim that there is a predetermination in the process. So yes, the obligation is to consult as best you can. And certainly there would be, in that situation where essentially Australia has directed this, a real legal risk that the decision would be unjustified in New Zealand. That doesn't mean you shouldn't consult. That means you consult as best you can. And the business in New Zealand and also in Australia will have to accept some level of risk. So it's a very difficult situation, and it does happen.
So just coming to some of the questions that were asked via the chat function, and I should say that if people need to drop off, if we reach 1 o'clock, please feel free to do so. And if we haven't got back to you, you can drop any of us a line, and we'll try and come back to you via email if need be. Just in terms of the questions we got asked, one of them is suspending employment an option as opposed to redundancy during a pandemic or a major event? And I think since I haven't answered any questions yet, I'll answer that one. But essentially, employers in New Zealand don't have any legal right to suspend employees in these sorts of circumstances. So if they want to suspend employees, generally they would have to try and reach agreement with them. There's been a lot of international press on a concept of furlough, essentially, so again, standing employees down. And I know in Australia there is a similar concept around standing employees down during downturn periods. We don't have that here, so again, as we say, it must be by agreement with the employee. And in some circumstances it has been done because employees are, as opposed to redundancy, they're kind of happier to keep a potential of work when that increases. But generally, an employer's options on a unilateral basis is to either make employees redundant or comply with the full terms of the contract and the statutory obligations. Another question we had is around the leave support scheme, and is the employer required to top up the payment, i.e. can it just pass on the payment or as a special leave, or does it have to top it up? There's a lot of different factors in relation to whether or not that has to be done, but generally when an employee is absent, your normal terms and conditions and your normal relationship applies. So they may be absent. If they have COVID, it's because they are ill. So they might be entitled to sick pay in those circumstances, and in which case, yes, the employer has to top that up if it doesn't meet their earnings essentially in normal times. If for example, you have agreed with your employees during that period of time that either they will take special leave and they won't receive full pay, they will just receive the wage subsidy, then no, but that's by agreement. If your employee doesn't have any form of leave, so they're not entitled, they've got, let's say they've tested positive for COVID and they are away sick, but they haven't got any entitlement to sick leave, then essentially there'll be a discussion with you and your employee as to whether the employee wants to take, for example, annual leave during that period of time. If they have no other leave entitlement, then you would just pass on the amount of the wage subsidy, but it's very much fact specific as to why the employee is taking leave and what your contract says and what you've agreed with the employees at the time. And the last question that I will throw over to either Simon or Scott, so you can stop listening to my voice, is if you had an employee being made redundant and they have no entitlement to compensation, but the bulk of the workforce, so for example 90%, is entitled to compensation, would the employee have an argument they should receive some form of compensation?
Scott, do you want to pick that one up, and then I've got one further question that we can deal with after that.
Sure. Whether an employee gets redundancy compensation is a matter for agreement or for the employer's policy. So you'd first look to your employment agreement. If there's nothing in there, you might look to an employer's policy, and sometimes a policy might apply to all employees. But absent that, and absent anything else, you probably haven't got a good argument that redundancy compensation should be payable. Having said that, you have a fairly strong moral argument, and certainly in a restructure process, an employee could make the point that they should be paid redundancy compensation. But it's unlikely that there will be a legal entitlement to redundancy compensation when the employment agreement doesn't provide for it, and there's no other employer policy which provides for redundancy compensation.
Okay, thank you, Scott. I appreciate we just passed 2 o'clock. We have had quite a few questions, and while Laura has mentioned, if we don't get to them all, what we will try and do is kind of answer them and perhaps send out a general update to all of you that have kind of participated or attended the webinar. But I'll just briefly deal with one final question before we conclude. So the question is, if you hire someone who is currently overseas and you agree for the person to start their employment whilst overseas, do you follow their country's employment rules or those of New Zealand? So kind of unpacking that, there's a couple of issues there, I think. I mean, from an immigration perspective, generally, if the individual is an overseas worker, generally their work visa or resident visa won't actually commence until they enter New Zealand. If they are on an open work visa, so for example, a partnership work visa, then they can theoretically work for anyone. But if they are on an employer-specific visa, as I mentioned, that generally won't start until they enter the country, but will be subject to conditions, potentially including where they perform their work. But from a general jurisdictional perspective, at a kind of very high level, jurisdictionally, the laws that govern employment, it's generally kind of deemed that the country with which you have the closest connection has jurisdiction. You look at factors like a governing jurisdiction clause in the employment agreement. So does that stipulate that the employment agreement is subject to New Zealand law? You would look at where the duties are performed, but obviously at this current time, there are some obvious reasons for people being offshore and performing work offshore if they can't get into the country. Scott, is there anything on else on jurisdiction that we would add?
The reality is, if you, as you're saying, Simon, it's about the connection to the country, and if you are here, working here or based here, then it's likely that New Zealand employment law will apply to you, particularly to the extent that you may bring a claim for unlawful discrimination or unfair treatment. And it may also be that bits and pieces of New Zealand legislation, like the Minimum Wage Act, will apply to you. So the courts are probably going to look at, as you said, Simon, what the contract says, but also look at how things operate in practice. And if they see a potential issue, they're likely to say, well, we can deal with it, or we can deal with it here in New Zealand. So you've got to be prepared for the potential that the court in New Zealand might intervene.
Okay, thank you, Scott. As I mentioned, we've just run a few minutes over, but I think we'll finish there, because we appreciate that some of you, or most of you, may have work to get back to, but we will try and address the outstanding questions that we haven't answered in writing. So just like to thank you all for attending. I'd like to thank both Scott and Laura for great presentations. I'd also like to thank our colleague Melissa Hu-Davidson, who helped with the technology, and hopefully look forward to seeing you all on the next webinar. So thank you very much.
Thank you.
Thanks, everyone.